This podcast is brought to you by PLI, the Practicing Law Institute. PLI is committed to keeping you ever current on topics that matter to you, like artificial intelligence. Learn more at pli.edu/AIPod.
Welcome to AI and Data Law, part of the PLI Evercurrent podcast. I'm William Tanenbaum, host of the podcast and head of AI and data practice at Moses & Singer in New York. In this series, we bring you the latest perspectives on AI and data through timely talks with thought leaders working at the intersection of AI, data, and the law. In this episode, my guest is Danny Ertel, the founding partner and director of Vantage Partners. Our topic is corporate responsibility for generative AI outputs. So on today's episode, we're very lucky to have Danny Ertel as a speaker. I'm going to ask Danny to tell us about his current position with Vantage in a moment. And one of the overarching things we're going to start with is how, broadly speaking, a regulatory environment is having its own impact on regulatory issues involving generative AI. So Danny, let's start with just having you share what Vantage is and what you do and how Vantage touches on the generative AI space.
Well, thanks, Bill. So it's kind of interesting because I'm not sure how Vantage touches the generative AI space either, but we're figuring it out like everybody else. Vantage Partners is a consulting firm, and we help our clients solve business problems that are best solved through collaboration, is the way I like to describe it, whether it's problems along your supply chain, problems with your business partners, research partners, go-to-market partners. And it's everything from remediating damaged relationships to launching new ones so that they don't get into trouble later, to putting in place the processes, the governance, the infrastructure, the things that you need to make those relationships work well, and also making sure that people have the right mindset and the right skills to execute on all that.
So of those issues at present, are you seeing that it's a mindset or an infrastructure problem? And I'm sure the answer is some combination of both, but how do you just see that part of the landscape?
I mean, I think with generative AI, everybody is eager to figure out what it is and to put a stake in the, plant their flag and to talk about what they're going to do in generative AI or how they're going to enable it or how they're going to control it or anything else. But I think we're only just now beginning to see what the potential use cases are. And it gets to be really interesting as people start with the way we started with basic automation, the way we started during the internet boom with basic technology. We come up with a few use cases, and before long, we decide that some of those use cases were silly and some companies go away. And then after a few years, we come back to some of those use cases again. I'm reminded of the early days of, Webvan. That was supposed to be the big thing. You can order your groceries over the internet, and they invested a lot of money putting infrastructure in place and then promptly went bust. And now we've got, whether it's Whole Foods and Amazon or DoorDash or everything else in between, and it's old hat. And so I think same thing will happen with generative AI. Right now, everything seems brand spanking new and cool and exotic. And over time, a bunch of it will just become second nature.
Yeah, I think I share that view. I think, at one point people would refer to it as e-commerce. And I think after a couple of years, it wasn't e-commerce, it was commerce.
Exactly.
You didn't call it railroad commerce. You didn't call it, hub and spoke commerce. It was commerce,
right?
Today's commerce. So you and I had talked earlier about kind of the quasi-regulatory issues surrounding input and output. So let's focus on input for a moment. And, let's just start with how you see the right side of input, that is having the rights to input something as a prompt into one of these generative AI tools.
So maybe I'm showing my age because I see these questions as sort of new instances of questions we've heard before. But I was listening to a forum recently at Harvard where I was reminded that the problems with, the application of technology to IP right, have been around since the player piano, the photocopier, the VCR, right? And
Yeah.
so we're getting some version of that again. But I think that there is this question about the training of the large language models and what kind of information and content can be used legitimately to train the models. And I think that we need to be a little bit cautious in over encouraging and over eliminating potential costs of training the model. And we'll talk a little bit about outputs as well. But when we're talking about inputs, there's information out there that has some protections around it, that is entitled to some kinds of protections around it. And I think that there are people on one hand saying, oh my God, you can't use any of it to train an LLM. And there are some people who are saying, no, 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 you're not really copying it. You're just sort of learning, extracting information from it. And so you can do whatever you want. And I think we need to be a little bit cautious as we think a little bit about how are you using the information? What are you creating from it? And what do you owe the original copyright owner, the original author?
Well, there are some who draw a distinction between putting input into the training model. So the training data set would get this input because the input becomes the data. That input comes from something someone has created that's cognizable under the copyright law. And then the argument goes, if it's in the training model, the training data set, and then the model uses the training set to become a model that was what was ingested as data into the training data is not part of the model. So then when the model operates, it's not using, let's call it infringing works for the sake of convenience, because the model in some metaphysical way sits on top or is derived from the training data, but the contents of the training data are not in the model itself. So I can see the logic of that in running it through kind of an analysis of infringement. I can also see the other side, that this is really just terrific, but somehow the model is using my stuff. My stuff being, I wrote a book. My book was quoted on the internet in some fair use academic journal, and this is no longer fair use. So I see those are the complicated steps that arise in an infringement analysis. I'm just going to ask what you thought the business thinking would be around that business step, given however you assess the risk. So I'm very pleased to have asked you 5 questions at once.
I mean, I think that it is possible, as you said, Bill, to kind of reason our way to either side of that answer, either side of that question. And I think that different people have a bunch at stake in trying to argue that there's only one answer that is correct or makes sense, when actually we're making a choice, right? We're sort of by fiat saying, yes, there is content in the model, or we're saying no, the model is built off of the content in some way, but is not the content itself. And I think this is one of those places where reasoning alone doesn't give us the answer. Part of what we have to ask ourselves is, what are we trying to encourage? And are we trying to encourage free for all, essentially, use of protected content to train and create these models? Or are we trying to encourage something more deliberate and measured that requires some sort of meeting of the minds or exchange of value to be able to proceed? And I think that's more of a policy question than a logic question.
I think I agree with that. And I think we now come to, if you're a business, you have 2 sides of this, right? You don't want to be liable for some kind of copyright infringement based on putting your own input into the system and getting output that embodies, or at least in some copyright way, is derived from someone else's copyrighted work, that is some other person's input, whether voluntary or not. So that's the one question I think we're talking about. So let's stay with that for a moment, and then we'll come back to, what does a company want to feed into, or at least make accessible to the model? I have a couple of comments on that. But as far as the output side, I would think that the company's risk is, how do I do copyright clearance to know that the output I'm getting is from some kind of policy or non-copyright analysis, taking the wrong balance of rights between my output and some third-party content creators' intellectual property rights in their own content.
I mean, I think on the output side, and I'm not sure if I'm going to answer your question here or not, Bill, but on the output side, I think about a couple different things, right? I think a little bit about whether you were infringing on some input, whether the output infringes. But there's also questions about whether the output is wrong, or whether the output is harmful in some other way. And I think that on the question of whether it infringes, or even on the question of whether it's wrong or harmful, I don't think we can let the model providers or the operators off the hook by saying, well, we don't really know how machine learning did it. We don't really know how AI did this, what transformations it used to come up with the answer. Because just because you choose not to know how the model works doesn't mean you shouldn't be responsible for what it does, right? Just like you can't discriminate knowingly through your rules and processes, you can't discriminate through the operation of your AI, which you say is a black box, right?
Mhm.
Just like you can't defraud somebody knowingly, you can't defraud them through the operation of the black box. So I think the question of sort of output and who bears the cost of the output or the accountability for the output shouldn't be different because it's AI doing it than because it's some other business process or some other automation doing it. And one analogy that I find works, to some extent, is thinking a little bit about generative AI the way we've started to think about, self-driving cars. And I don't see us saying that the manufacturer of the self-driving car is not going to be liable for the harm that that product might do if they use erroneous maps, right? The inputs are flawed in some way. Or if the radar couldn't detect motion in the rain because it wasn't sensitive enough, if the equipment they used or the programming they used was not appropriate, we still say you are responsible for the outputs, for the outcomes. It's an imperfect analogy like any other analogy, but I think that when we're talking about generative AI and the outputs, again, there's a choice. Do we immunize the providers of AI, or do we not give that blanket immunity? And you and I had a conversation before about the example of the Digital Millennium Copyright Act and how it was designed to provide a whole bunch of blanket protection to the platform providers for harmful content that was posted on those platforms or infringing content that was posted on those platforms, so long as they exercise certain responsibilities to take things down when notified. And I think the purpose of that was to encourage the platforms, to encourage the development of the internet and social media. We may be regretting some of that.
Yeah, mission
But
accomplished.
yeah, mission accomplished.
Yeah.
And I think we got to ask ourselves, do we want to over encourage the development of generative AI with some of the accompanying consequences? Or do we want to be a little bit more deliberate about saying you're protected from your outputs so long as you followed some process?
And I want to come back and kind of ask you, about how those things would be regulated. What would be the generative AI equivalent of DCMA, and whether it's somehow buried in the executive order, which is kind of a redo on this. But the thing I'll observe is that I think there is a similarity between generative AI and the accuracy of, self-driving cars' ability to self-drive. You can probably get a car, 95% of the way, and it's really, really hard to close that 5%. It's difficult to decide whether it's a shadow or a pedestrian. Now, I think with automobiles, it's going to be pretty clear. If somebody gets killed, somebody's going to be liable, unless there's some insurance writ large solution to that 5% gap. But if we come back to I think it'll probably get better, but there's always going to be a gap between what you can really do and what just somehow happens. So I don't know if I want to ask you a question about that because I don't know if there's an answer, but it just occurs to me in these two kind of contemporaneous developing technologies, they have the same problem getting to a really reliable state.
I think that's right. And all I'm making is what I think is a relatively modest point, which is
Right.
let's not jump to believe that in order to get more development and more investment and more R&D, we have to immunize the providers of AI against that 5% or whatever it is that is commercially infeasible or technically infeasible to close. But to say, no, you're going to have to bear some of that risk and some of that cost as part of your business model.
And would that be under a product liability avenue or some kind of tort avenue?
I mean, it might, right? So that's a little bit the difference between sort of looking at the inputs and the outputs. If we're talking about outputs that are harmful, that's sounding in tort, right?
Right.
If we're talking about some infringement of the inputs, that's sounding a little bit more like IP protection.
Yeah, and I think both exist at the same time, right? Because when you're creating content, which is kind of the class of use of generative AI, whether it's written or an image or music or, a deep fake of Danny or Bill, it's an output. In my mind, it's still going to draw the distinction between like artistic copyright and functional copyright, between Broadway and software. I think there will be a distinction in part because calling software an artistic work in the same category of books, it's got its own artificiality, right? That's built in, and now we're building on the artificiality that we use for convenience. So if we kind of take it from what you've said, that it's at some level not right to over encourage a lot of inaccuracies as the price of rapid technological development along a path that we'll figure out as we go along the path, which I think is probably a current position for some of the developers.
Yeah, and I would say we don't need to impose regulatory liability or constraints necessarily based on sort of inaccuracy, right? We don't want to have an uber regulatory scheme that says unless you can produce 100% perfect output, you can't produce anything. But I also don't want to say that you're not responsible for the harms that you cause, right?
So there are two stages to that. One is to say we're not giving you all incentive and no responsibility.
Right.
And the other is saying responsibility means some kind of responsibility at the end. And that some level, an assertion that you've tried hard isn't good enough if the output is negative enough. So
there's also a distinction. There's a distinction, Bill, which I haven't thought through yet, whether it helps us figure this out or not. But there is some piece of generative AI, some of the use cases that are a lot like outsourcing using labor arbitrage and automation using standardization, which are about reducing the cost of carrying out an activity.
Mm-hmm.
And when you reduce the cost enough, you make certain things commercially possible that weren't commercially possible before. And there are some use cases for generative AI that are about doing things you couldn't have done without the ability to detect these patterns at all, that they might be enhancing the human actor's ability to do certain things, not just reducing the cost of getting those things done. And I wonder whether we might have some different treatment. I don't know if it's a distinction that holds up, but I wonder if you might have some different treatment of accountabilities and encouragement around things that are purely about reducing costs versus they're about doing new and difficult things.
So, how do you have a projection of how that might play out, or at least what the countervailing arguments will be, or countervailing business developments?
I mean, in some ways, I think that if the use cases around AI are primarily around cost reduction, then I'm much less inclined to say let's overstimulate or let's encourage by providing some kind of immunity. Because if your whole business model is about ripping some cost out, then you need to make sure you're actually accounting for all of the costs of what you are doing to rip out the obvious intangible costs. But if the use case that you are developing is around doing something that couldn't be done at all without this technological enhancement, then maybe we got to give you a little bit more room to experiment and try things out. I don't know if that plays.
So, how does that translate then? Just as we're working this through, you've got some OpenAI or someone else who's providing a model, and some outsourced provider, just to continue that analogy, is taking the model and it's coming into company A, and company A is saying, okay, here's our data set. We want you to apply that model to our data set. And we want you to help generate not a replacement for human activity, but we want to enhance it. So now you've got, I think, the provider and let's just call it the outsourced customer. They're both trying to do the same thing. The provider's trying to provide a tool, and the customer's trying to use the tool to get an output where they're kind of aligned on the functional result of the output. Are both of them running the same risks from a policy point of view in your mind?
I don't know. I mean, if the provider is creating a model that its purpose is to help them or to help their client do something much faster and cheaper than it can be done today. Right?
So let's say
write screenplays or write code.
Right. Let's say write code.
Write code. So you want to write code without having to worry about those pesky engineers, whether they are, in a low-cost location or a high-cost location. You just want to be able to write code cheaply and quickly. Versus you are trying to you're trying to do drug discovery by detecting very small patterns in immune response of different kinds of reagents. I don't know.
Sure.
And what you're doing is you're saving having 100 programmers do the job. The other one, you're doing something you couldn't do at all because you couldn't do a brute force kind of look to find this cure. I'd be more encouraged to provide some immunity stimulation, whatever, to someone who's trying to push us to do something we couldn't do before than to someone whose business model is just to reduce the cost of doing something that we could do all day long without the generative AI. Maybe that's too simplistic, but
yeah, I think that's a useful distinction. Giving rise to a whole bunch of edge cases, but I still think it's a useful distinction. And I think edge cases are always unavoidable.
Right.
Especially when it's convenient to have some. Do you think this is possible to do at like an industry self-regulatory atmosphere? I'm just trying to think how we're going to implement. We don't want to overstimulate. We don't want to over-immunize. And we don't want to kill drug development. So Danny and Bill have identified the problem pretty well here.
Right.
Got the problem nailed.
Yes. Maybe ChatGPT could have gotten here faster.
Undoubtedly.
Yeah. I don't know. I mean, Tim Wu had an interesting op-ed recently about being careful not to over-regulate in this area, because then only the really big providers will be able to compete, because they're the only ones who can afford to comply with cumbersome regulatory schemes. And go ahead.
I was just going to say that's the argument in favor of regulating if you're an incumbent, right? I'm here. I can take some restrictions because I can afford to build them into my model, so to speak.
Right. And Tim was making the argument we got to be careful not to create an oligopoly or perpetuate an oligopoly or too much concentration by creating a regulatory scheme that only the very large incumbents can afford to comply with. And I'm sympathetic to that, but not if the alternative is to say, well, do whatever the hell you want, right? There has to be some kind of accountability for the inputs that you are tapping and some kind of accountability for the transformation or extraction that is producing some outputs. And whether we leave that accountability entirely in tort, as you were asking, or whether we make it a much more structured process, I think we have to strike a balance, right? I don't think that there is a one size fits all for this.
So let's shift gears a little bit because I think we've kind of run out what we're going to do on how to regulate this.
Yep.
At least I've run out of bright ideas about what to say about how we're going to regulate this, except to observe that if you had the power to influence the regulations, you would favor immunization and just kind of a big safe harbor for it's a very complicated problem. I did my best. You know, I'm remembering when I was a law student and there were cultural differences. If you were building a dam in England, you were building a dam in the American Southwest. The dam broke and flooded everybody downstream. In the Southwest, it was that's just the price of commerce or the price of progress because we need these dams. We're in a quasi feudal society, then it would be like, I don't want to be flooded by anybody, so don't flood me. So the liability went in very different directions.
Right.
As did, for what it's worth, the technology. In England, the railroads, the tracks were really, really well built and the engines followed them very well. In the United States, the tracks were kind of sloppy, so the engines had all kinds of more flexible, let's just call it a suspension, so that they could deal with bad tracks. So you got good engines and bad tracks versus really good tracks and kind of rudimentary engines. So I think we're in some bizarre way kind of at that same inflection point, right? Got people who've laid down some tracks, and you've got some startup companies that say we don't want to have all the sloppiness and an open AI where you're just pulling the internet and your AI is like a toddler who just says, okay, those are the words that are predicted. I don't know what they mean, but my model predicts this is the next word. Now called a hallucination, someday to be called something else. So we can step maybe into the Vantage world, and you're working with a company that's trying to say, okay, this is the next disruptive technology, and I've got to adopt it in the way that I've adopted a whole series of technologies. And now I've kind of assessed the risks here, but there's a commercial benefit to me, but I'm not really in the business of infringing people's this other work. That's not the business I want. Are we talking now about what they do at a corporate policy level and how much influence they have over the model providers?
I mean, I think the as you were noting with the example with the dam building, right? The those deciding whether to build a dam or not, right? Were taking into account the legal context in which they were doing that. And those laying track and building locomotives were taking into account the allocation of liabilities that was inherent in the system. So I think that some of the guideposts that get put in place are going to affect how the business models are deformed around those guideposts.
So now we're focusing, Danny, on what the guardrails are and how users, developers, everybody in the ecosystem here is going to make a decision based on where they see liability or risk coming from the guardrails. And I was trying to focus on, well, we're in this environment. We don't have the guardrails yet, but we do have the use cases and we do have the tech. And we do have the risk, and we don't know what the risk is because we don't know how much liability attaches to it, in part because we don't have a copyright law that really tells us what's infringing or not. And that's going to be decided as cases kind of get ramped up and focus on this problem. So I'm still trying to ask the question of, if you're a company, what do you do here?
Right. So I think that if you are uncertain, for example, on whether using certain data to train your model is going to infringe or not, then you're going to be a little bit cautious about how you tread, right? And you're going to start by looking for data sources that you know are non-infringing by definition. You are going to next take a look at data sources that you own or you've negotiated some rights to be able to access for these particular uses. And you're going to set a pretty high bar when your team wants to tap other data sources that are going to expose you to some liability that you can't control. And I think that's okay. I think that the downside of that is that we slow down a little bit the development because of that uncertainty. And that uncertainty, I don't think anybody's going to be able to quantify how much of the data is going to be affected by that uncertainty and how much it's going to slow down development because some people will just say, hell with it, I'm going to bet that this is not going to be infringing and I'm going to use it. And others are going to say, I am going to focus my business model around providing value with the things that I know are non-infringing. And then there'll be some folks who will straddle the middle. And I think that's okay, as opposed to everybody deciding that they can take whatever they want.
That makes sense to me. And then it rolls out in my mind whether you have different zones of liability risk depending on your industry. So to go back to pharmaceuticals, are you willing to say we're going to take some more liberties and maybe we'll be able to police the output a little bit because once we have the output, we can test it, before we engage in patient treatment.
I mean, I think that, on the output side, as we were saying a little bit earlier, there's some different types of cost or harm involved. Some of those is it harmful because the output was created by infringing on some protected materials, but the output itself is somehow devoid of any of that protected material? Or is the output harmful because it actually harms people in some way?
Right.
Right. And so with pharmaceuticals, you have the existing protections that deal with actually hurting people. And you are left with this question of, if I created something that saves people's lives and is devoid of infringing content, but may have been arrived at by infringing on content, you might give that some slightly more, benign neglect sort of treatment.
Mm-hmm.
Whereas in some other domains, entertainment or something, you might err on the side of protecting the creative expression, right?
Which, if you go back to the Constitution, is the point of copyright law, right? It used to be 14 years, but the point was really just to encourage creativity. That was
Right.
the point. The point was not to get a 70-year renewal from it. But
Right.
We've come a little bit. I think if you go back to first principles, that's what copyright is supposed to do. It's supposed to provide some means of encouraging creativity by providing some means of protection against it. I mean, you raised an interesting question that I think is outside the scope of today's episode, but I think it's an unanswered question. But I'd, go ahead and speculate on this one. What kind of property right is data? I mean, you talked about we're going to put data we own into this thing. Tough problem, I think. I don't think data was considered to have a real business asset class of its own until recently, but now it does. Now it'll drive a deal. Now it'll drive the economics of the deal. My own view is,
I mean, and there's data and there's data, right? Because there's what's my name and what did I buy yesterday for lunch, so somebody knows that I like that and they can sell me something else. And there's data that says there are these efficiencies gained when you run a process one way versus when you run a process a different way, right? Process data.
right.
Or there's data in patterns that are not about any individual or that are not about a particular artistic expression. So is data property? I mean, I would probably err on the side of saying that it is information that somebody is going to put to some use that somebody else had to put some effort into collecting and assembling and organizing, and that editing and collecting and assembling and curating and so forth, going back to Locke, right, is the mixing of their labor with the resource, creating something of value, and thus should be protectable. But that's right?
Yeah. I come out on the side that if you can't hit full ownership because it's, in your mind, too intangible to be owned, and let's just concede that's a perspective, I would fall back to a regime based on control, that at least you could, control access, you could control use, you would have the right to do both with the right to control. And I guess in my own mind, I'd kind of, at least for drafting a contract, which is what I would do, I would kind of skirt the issue of ownership rather than have esoteric debates over that. In part because someone's going to be afraid that I don't care about this transaction, but 3 transactions from now, I don't want someone telling me that I gave away ownership of something that I shouldn't have, and that we didn't even know we owned until 2 years from now.
I mean, ownership in some ways is a conclusion. And then if you agree, if you start with the conclusion, then people start sort of deriving things from it. But I like going back to the notion of property as a bundle of sticks, right? And so which sticks are you giving away and which sticks are you not?
That's interesting. So how would you do that? Not with raw data, but with like databases. Just, data is an asset class as opposed to, I don't know. I mean, I think data gets its meaning from context. If you tell somebody it's 50 degrees outside, what are you telling them? If you're telling them it's 50 degrees in Hawaii, you're telling them it's cold. If you're telling them it's 50 degrees in Portland, Maine, you're telling them it's hot.
Well, yeah. I mean, when it's 60 degrees in Boston, if it's the springtime, people put on shorts. And if it's the fall, they put on sweaters. And it's the same 60 degrees. But I mean, I think that property rights in a database, and again, there are people who have spent a lot more time than I have dealing with this, right? But there's the question of the right to read the data. There's a question of the right to sell the data to somebody else. There's a question of the right to extract some patterns or meta information from the data. There's a question of the right to reproduce the data. And I think you could make some different choices around each of those.
All right. Well, now that we've solved that really difficult problem in about 77 seconds here, I'm impressed with both of us. But I think we should kind of finish up with the discussion. So now we've decided that, different players in this ecosystem are going to assess risk differently. And that depending on the benefit of the outcome or the nature of the outcome. So you said, okay, so if the play's infringing, that's not the same thing as slowing down the development of a cancer treatment. I would draw a distinction between depriving people of entertainment and depriving people of a couple of years of their life. That would be a distinction I would be comfortable with. So that leads me to the question, is this going to be, in a good way, balkanized by kind of industry practices as to what's an acceptable industry given an acceptable class of output?
I mean, I find it hard to believe, right, that our legal system will develop different rules for things like generative AI abilities or accountabilities, depending on the industry or the field. Maybe that'll be true. It's hard to think about.
So it's hard to think about as a matter of first principles and harder to think about as the fact that industries don't have permanent boundaries, I guess.
Well, there is that, right? And there is the ability of people to stretch arguments any which way you want to stretch them to make the case for how, human life ultimately depends on, the ratings this movie got from the crowd or whatever.
Yeah, we got to go there. I get that.
Yeah. I think a lot of our industry walls are going to be crumbling and are continuing to crumble. And, bioinformatics is a thing now that didn't used to be. And I think that more and more, we do a lot of work in the pharmaceutical space, more and more of our clients are having to be much more data and computation savvy than they used to be. And they are having to worry about questions about, well, I have the right to use your data and I have the right to use their data, but do I have the right to put those two data sets together? And it's causing people to be uncertain about what they are or are not allowed to do. And I think that if we were to develop for the world of generative AI, very different rules depending on the domain, that will make that even more complicated.
I agree with that. I'm just trying to find if there's some safe harbor, safe harbor, rather, a company could rely on as it's trying to make this assessment that in the pharmaceutical industry, certain amount of risk subject to, normal FDI product certification to use generative AI. And then a different view is you just can't go out to the internet, absorb all kinds of copyrighted material, run it through 3 different models and training sets, and then say somehow the outcome is so different from the ingestion that we don't have a trail of actual infringement. There's, the traditional tests of copyright and access are impossible to apply, and since they're impossible to apply, there can't be infringement of results. That may be a questionable thing right there, but the thesis of my question was in different domains, at least on an ad hoc basis, there could be a reason for different assessments of risk and right and wrong in a different calculus of benefits versus stepping on somebody's other rights.
Yeah, and I think, whether we like it or not, we end up, and courts end up, looking for analogies or ways of operating that provide a little bit of guidance when we bring in automation. So I think in pharmaceutical, for example, somebody might say, well, it's always been the case that people publish scientific papers and other people read them and they use the knowledge in those scientific papers to dream up new experiments and to come up with new ideas. And so if your AI model learned something from all those scientific papers or whatever the modern analog is of those scientific papers, and you use that to come up with an idea, that's going to feel less infringing than if your AI model looked at a whole bunch of pictures and came up with a picture that was a composite or somehow based on all those other pictures.
Well, I think, we've done about as much as we can do in one podcast episode to decide the future. And I really appreciate your insights because I think you've raised some really good points and talking points, especially about, kind of the calculus of harm, regardless of some technical legal structures that don't yet exist, and not erecting inadvertent immunity or zones of immunity out of a rush just to get some certainty in place. So, that's what I'm taking from this discussion, and I found it very useful. So, Danny, thanks so much for participating. I think it's been pretty enlightening.
Pleasure, Bill. Thanks for your questions.
Thanks for listening to AI and Data Law, part of the PLI Evercurrent podcast. Please note that the views and opinions expressed in this podcast represent those of the host and individuals being interviewed, and not necessarily those of PLI. For more AI-related content from the Practicing Law Institute, visit pli.edu/AIPod.